You are driving home on a Tuesday night. The road is quiet, and your playlist is perfect. Then you see the blue lights flash in your rearview mirror. Your stomach drops. You pull over, turn off the music, and roll down the window. The officer walks up, shines a flashlight in your face, and leans in. Then he says the 6 words that change everything. I smell the odor of marijuana. You freeze. Maybe you haven't smoked in years. Maybe your friend smoked in your car yesterday. Or maybe you have absolutely nothing in the car and you're completely confused. The officer stares at you, waiting for a reaction. He says, "Step out of the car, I'm going to need to search it." What do you do? Do you argue? Do you get out? Do you tell him he's wrong? Most people in this situation make a critical mistake in the first 30 seconds that guarantees they end up in handcuffs. Today, we are going to walk through exactly what happens when police claim they smell weed. I am going to teach you the law behind the plain smell doctrine. We will look at how the legalization of hemp has created a massive loophole that courts are fighting over right now. And I will give you the specific scripts you need to protect your rights without getting hurt. I am not your lawyer, and this is not legal advice. I am a legal educator here to help you understand the system so you can survive it. Let's start. Meet Elias. Elias is a 27-year-old graphic designer living in a state where medical marijuana is legal, but recreational use is still a gray area. He drives a 10-year-old sedan that has seen better days. One evening, Elias is driving home from his shift. He has a broken taillight, which is why Officer Miller pulls him over. Elias knows the drill. He pulls over safely, he turns off the engine, he puts his keys on the dashboard and his hands on the steering wheel. Officer Miller walks up to the window. "License and registration," the officer says. Elias hands them over smoothly. Then Officer Miller pauses. He sniffs the air dramatically. "Son, I'm detecting a strong odor of burnt marijuana coming from this vehicle." Elias is confused. He doesn't smoke weed. He hasn't had anyone in his car who smokes weed. But Officer Miller looks certain. "When was the last time you smoked?" the officer asks. This is the first trap. Elias thinks, well, I haven't smoked, so I should just be honest and say never. But if Elias says never, and the officer claims he smells it, the officer might document that Elias is lying. If Elias says a few weeks ago, the officer now has an admission of drug use. Elias stays silent for a second, unsure of what to say. Officer Miller presses harder. "Look, if you have a little bit on you, just tell me now and I'll write you a ticket. If I have to search and find it, you're going to jail." This is the negotiation phase, and it is almost always a trick. Elias panics. He says, "I don't have anything, officer. Go ahead and look if you want." And just like that, Elias lost the game. He gave up his Fourth Amendment rights. Officer Miller opens the door, Elias steps out, and the car is torn apart. They don't find weed, but they do find a pocket knife under the seat that is slightly too long for local ordinances. Or maybe they find a prescription pill bottle with the label torn off. Now Elias is in handcuffs, not for weed, but because he consented to a search he didn't have to. Let's rewind this scenario and break down the legal mechanics of what just happened. To understand this, you need to understand a legal concept called probable cause. Your Fourth Amendment protects you from unreasonable searches and seizures. Generally, police need a warrant to search your property, but cars are different. Because cars can move away quickly, the Supreme Court created the motor vehicle exception. This exception allows police to search your car without a warrant if and only if they have probable cause. Probable cause means the officer has enough facts to believe there is a fair probability that evidence of a crime is in the car. For decades, the smell of marijuana was the golden ticket for police. If an officer said, "I smell weed," that was it. Courts agreed that the smell of marijuana was unique and illegal. Therefore, the smell alone was probable cause. It gave them the legal right to search every inch of your car, your trunk, and sometimes even you. This was known as the plain smell doctrine. It's a cousin of the plain view doctrine, which says if an officer sees illegal drugs on your passenger seat, they can seize them. Plain smell works the same way with the nose. But here's where things have changed in 2024 and 2025. The game is different now. Why? 2 words: industrial hemp. In 2018, the US government legalized hemp. Hemp is cannabis with less than 0.3% THC. Marijuana is cannabis with more than 0.3% THC. Here's the problem for the police. Hemp and marijuana look exactly the same. They're the same plant. More importantly, they smell exactly the same. There isn't a human nose on Earth that can distinguish between the legal smell of hemp and illegal marijuana. Even drug-sniffing dogs cannot tell the difference. This scientific fact has created a massive legal battle in courts across America. Defense lawyers are arguing a new theory. They argue, if hemp is legal and hemp smells like weed, then the smell of weed is no longer evidence of a crime. It could just be evidence of legal hemp. Therefore, the smell alone cannot be probable cause. And just like that, many states have just agreed. Courts in Pennsylvania, Minnesota, Massachusetts, and recently Florida have ruled that the smell of marijuana alone is not enough to justify a warrantless search. This is a huge shift in constitutional law. However, you need to be very careful. Not every state agrees. In Wisconsin, the Supreme Court ruled that the smell is still probable cause, even though hemp is legal. They essentially said, it's close enough and we trust the police. So, depending on which state line you cross, your rights change completely. Let's go back to Elias. If Elias is in Minnesota and the officer smells weed, the officer generally cannot search the car based on that smell alone. The officer needs probable cause plus. That means they need the smell plus something else. Maybe Elias has blood-eyed eyes. Maybe there's a baggie on the seat. Maybe Elias admits to smoking. This is why the officer was asking so many questions. When did you last smoke? Just give it to me. He was fishing for that plus factor. He needed Elias to add more evidence to the pile to justify the search. When Elias said, "Go ahead and look," he solved the officer's problem. Consent overrides everything. If you consent to a search, it doesn't matter if the smell was probable cause or not. You just gave them a permission slip. So, let's replay the scenario. This time, Elias is going to handle it like a pro. Officer Miller walks up. "I smell weed. When was the last time you smoked?" Elias stays calm. He keeps his hands on the wheel. He looks the officer in the eye. Elias says, "Officer, I haven't broken any laws." Notice what he didn't do. He didn't lie and say never. He didn't confess and say yesterday. He simply stated he hasn't broken the law. The officer gets aggressive. "Well, it smells like a dispensary in here. Step out of the car. I'm going to search it." Now this is the scary part. If an officer orders you to step out of the car, you must step out. The Supreme Court case, Pennsylvania versus Mims, gives officers the right to order the driver out of the vehicle for officer safety. Do not refuse to get out. Do not lock the door and roll up the window. That will get your window smashed and you'll be dragged out. Elias unlocks the door. He steps out slowly. He closes the door behind him and locks it. This is a subtle but powerful move. Closing the door shows you are not abandoning your privacy. Locking it prevents the officer from just poking his head in casually. Officer Miller says, "Hand me the keys. I'm going to check the vehicle." Elias takes a deep breath and delivers the most important line of his life. "Officer, I do not consent to any searches." He says it clearly. He says it loud enough for the body camera to hear. "I do not consent to any searches." Now, Officer Miller might search the car anyway. He might say, "I don't need your consent. I have probable cause because of the smell." If that happens, Elias does not physically stop him. He does not fight. He does not scream. He stands silently by the police car. Why? Because the side of the road is not the courtroom. You cannot win a legal argument on the side of the road. You will only lose. If Officer Miller searches the car illegally, Elias's lawyer will fight it later. The lawyer will file a motion to suppress evidence. The lawyer will argue, "Your Honor, this search was based solely on the smell of marijuana." Under the laws of this state, and because of the legalization of hemp, that smell was not probable cause, and since my client clearly stated he did not consent, the search was unconstitutional. If the judge agrees, anything found in the car, the pocket knife, the pills, the hidden cash, gets thrown out. It disappears from the case. But if Elias says, "Go ahead and look," the lawyer can do nothing. The evidence stays. Consent is the enemy of defense. Now, let's talk about some common myths. Myth number 1. If I have a medical card, they can't search me. False. In many states, even if you have a medical card, the smell of burnt marijuana can still be probable cause for DUI. Officers will argue that while you can possess it, you can't smoke it while driving. Also, in some states like Illinois, the smell of raw cannabis, unburnt flower, is a huge debate.
Recently, courts have gone back and forth on whether the smell of raw weed implies you are transporting it improperly, not in an odor-proof container. So, having a card does not make you bulletproof. Myth number 2. I should tell the officer it's just hemp. This is tricky. Technically, telling the officer I have legal hemp explains the smell. It provides an innocent explanation. However, you are still admitting to possessing a substance that looks and smells like drugs. Most lawyers will tell you, do not identify objects in your car. Let the officer figure it out. Anything you say can be used against you. Nothing you say will be used to help you. If you admit to having hemp, the officer might say, well, I need to test it to make sure it's not marijuana. And now they are searching your car to find the hemp you just admitted to. You talked yourself into a search. Myth number 3. If I'm innocent, I should just let them search to get it over with. No, never. Police cars are dirty. Your friend might have dropped something, a previous owner might have left something, or the officer might interpret something innocent as something guilty. Maybe you have a bag of empty baggies for your kid's lunch. The officer sees drug distribution paraphernalia. Never consent. Let's break down the specific steps you should take if this happens to you. Step 1. The pullover. Signal, pull over safely, turn off the car, light on, hands on wheel. Step 2. The accusation. Officer says, I smell weed. You say nothing or I haven't broken any laws. Do not apologize. Do not tell a story. Step 3. The order. If asked to get out, get out. Close and lock the door behind you. Step 4. The search demand. Officer says, I'm searching the car. You say, I do not consent to searches. Repeat it if necessary. I do not consent. Step 5. The aftermath. If they search anyway, stay silent. Do not answer questions about what they find. Is this yours? Silence. Who does this belong to? Silence. Call a lawyer immediately after you are released. Now, there is one major exception we need to discuss. Reasonable suspicion versus probable cause. This is a lawyer term, but you need to know it. Reasonable suspicion is a lower standard than probable cause. It allows police to detain you, hold you, to investigate, but it usually does not allow a full search of the car. However, in some states, the smell of weed might give them reasonable suspicion to perform field sobriety tests. They might want to check your eyes. They might want you to walk a line. If you fail these tests, they can arrest you for DUI. Once you are arrested, they can search your car as a search incident to arrest or an inventory search before towing it. So, the smell can indirectly lead to a search if you fail the sobriety tests. In many states, you can refuse field sobriety tests, but you generally cannot refuse the chemical breath or blood test at the station without losing your license. Know your state's specific implied consent laws. Let's talk about passengers. What if you're the passenger and the cop smells weed? The law is complicated here. Generally, if the smell is coming from the car, officers often search the whole car and everyone in it. However, recent cases in places like Maryland have held that the smell of marijuana alone on a person is not enough to search that person. But again, this is evolving. If you're a passenger, the rules are the same. Remain silent, do not consent, ask if you are free to leave.
Let's zoom out and look at the big picture. Why is this legal battle happening? The Fourth Amendment was written to protect privacy. The plain smell doctrine was a tool for the war on drugs. Now that the war on drugs is winding down in many states, the tools are being taken away. Police are resisting this change. They rely on the smell of weed to find guns, cash, and other drugs. Defense lawyers are pushing back, arguing that the Constitution doesn't have an exception for things that smell like plants. This friction is where you, the driver, are caught in the middle. You're the test case. Don't be a bad test case. A good test case is someone who remains silent, refuses consent, and lets their lawyer fight the battle in court. Remember Elias? If Elias refuses consent and the officer searches anyway and finds that pocket knife, Elias has a fighting chance. His lawyer can file a motion citing the 2024 rulings in his state. The judge might say, "Officer, you testified you smelled marijuana, but you also testified you cannot tell the difference between marijuana and hemp. Therefore, you did not have probable cause. Case dismissed." That is the power of knowing your rights. It doesn't stop the ride. It doesn't stop the search in the moment, but it gives you the key to unlock the handcuffs later. One final piece of advice. Keep your car clean. Don't have loose tobacco, ash, or air fresheners hanging from the mirror, which is illegal in many states anyway. Don't give them a reason to stop you. And if you do smoke legal hemp or marijuana, transport it in a sealed, odor-proof container in the trunk. Don't drive while smoking. Don't hotbox your car. You're just begging for a headache. So, the next time you see those blue lights, take a deep breath. You know what to do. Hands on the wheel, silence is golden, and never ever consent, because your rights are like your muscles. If you don't use them, you lose them. Stay safe, stay educated, and drive carefully. See you in the next video.